Good afternoon, everybody, and thanks for joining us today. We're looking forward to this discussion about psych claims because, well, psych claims are my favorite claims to deal with, both in terms of deposing doctors, psychiatrists, and psychologists, deposing applicants. We get into the most interesting of fact patterns and claims, and we're going to talk about that and all of the various defenses that are involved in psychological claims, far more complicated and convoluted than any other type of claim that I can think of. Wide variety of claims, and there are some serious and legitimate claims. I know oftentimes we look askance at workers' compensation for psych claims, and for good reason, but there are some serious and legitimate claims. I once had a case in which the applicant was the secretary of a solo practitioner attorney. He had formerly been a judge, and a defendant in the case that he was handling came in and shot and killed the attorney. Obviously, his secretary had some serious repercussions from that psychologically. She was treated kindly. We provided her benefits. We didn't do any depositions, didn't do any research, just provided her the benefits, and she was a good person to whom bad things happen. That sometimes happens. Provided her benefits, and within 6 months the case was resolved to everybody's relief. Fraudulent, on the other hand, you've seen them. They're all out there, and I love talking about those. And then there's even the downright silly. We had a while back trying to prove either apportionment or causation in a psych claim, and the psychiatrist was asked about there's a typo there, about the death of a sibling. Didn't the recent death of a sibling contribute to the applicant's stress? Believe it or not, the doctor's response was, well, he had lots of siblings, so the impact of the death on just one wouldn't be terribly significant. Yeah, that's the silliness that we deal with in California workers' compensation. How do we handle the legitimate claims? Well, we're friendly, we're outgoing, we're supportive. And in the right case, we do as little discovery as is needed. No need to make the injured worker suffer through again, if at all possible. On the flip side, the fraud and silly, time to take the gloves off. Time to depose them about all relevant factors. And what are the relevant factors to a workers' compensation claim? Everything. Think about it. When you break somebody's leg, we're entitled to investigate all relevant information. So prior information or medical information regarding that leg, the hip maybe the alternate leg or the opposite leg, anything that's relevant. But what's relevant in terms of psychological claims? For crying out loud, Freud said that our potty training was relevant to our psychological makeup. So that leaves a pretty wide berth in terms of what we can ask the applicant. In fact, I've only run a couple of questions in my entire career that have been objected to, in which the applicant has been ordered not to answer, and in all but one of them, I've gotten a judge to order that they answer the case. So we emptied that closet of skeletons and look for anything and everything we can do. Why do we ask all these mean questions? A couple of reasons. Number one, they have to prove substantial causation. So if we can prove there's lots of skeletons in their closet demonstrating or causing the majority of their psychological problems, we win. And if we don't win on the COE issue, there's always apportionment. So absolutely no reason to not take the gloves off in these fraudulent or silly claims. What's the toughest, meanest question in a psych claim that I've ever had the opportunity to ask a claimant? Oh, ma'am, I'm confused here. Could you please tell me, was it you who gave your husband the STD, or did he give that to you? I don't know about you, but that not only would that be a potential work comp injury, but it would also be a potential homicide at my home. But that's how mean and nasty some of these questions can get. And with the fraudulent cases, like I say, you have to take the gloves off and investigate everything, including that. Defending psych claims without an organic brain injury. You would think, would you not, that if an applicant is going to be able to bring a workers' compensation psychological or psychiatric claim, there would be some sort of there would be a requirement of organic brain injury. And that oftentimes is the case everywhere else, but not in California. Surprise, surprise. There need be no objective demonstration of organic brain injury, or for all purposes, no objective findings whatsoever. We'll talk about that in the GAF score, the GAF score, and how it's based on subjective complaints almost wholly at our next session next month. So without any requirement of objective findings, there's a provision or an opportunity for lots of opportunities. Obviously, we can't see a quote-unquote broken psyche. We have to listen to the subjective complaints and have our psychiatrists and psychologists rely on subjective complaints. So there's lots and lots of abuse, and as a result, and there's much, much, much more abuse 15, 20, 25 years ago when I started in this industry, which has resulted in lots of legislative changes, all of them good. In the bad old days, if you were laid off, you filed a claim form. If you were fired, you filed a psych claim form. If you're disciplined, you filed a psych claim form. In 1989, just as I was getting my feet wet in workers' compensation, we established via statute, Sacramento legislature established a new and higher threshold for compensability of psychiatric injury. And they also in 93 included post-termination claims and good faith personnel claims, all of which we will go over. That new and higher threshold went from 10% industrial causation, needed to prove 10%, to substantial causation with certain limited exceptions, all of which we will go over in short order. So you want to file a claim form, you want to make a psyche claim, you need to prove injury AOE COE. You need to find somewhere around the 3208.3 hurdles. You must prove that you have an injury in accordance with accepted medical standards. You have to prove that it was caused by actual actual events of employment, and that was predominantly caused. By the way, 3208.3, I've just mentioned it. It is almost exclusively the only labor code provision that we're going to be discussing in the next couple of hours. It is quite the statute, includes lots of points and lots of case law defining and explaining exactly what the provisions of 3208.3 mean. So, affirmative defenses only applying to psyche. We've got the post-termination defense, the 6-month rule, and the good faith personnel action. What about hurt feelings? You're sad, you're angry, tough luck. We do not cover sad feelings or angry, somebody being angry. They have to have a diagnosable problem, an actual diagnosable problem, as defined by the American Psychiatric Association's Diagnostic and Statistical Manual of Mental Disorders, the DSM. Back in the old days, doctors were actually coming up with their own descriptions or their own definitions and new and strange diseases that they alleged applicants, a psychological applicant or psychological claimant had suffered. No more. And yeah, well, that's not supposed to be anymore, but doctors still occasionally do it. So when you see the diagnosis, I recommend you do a little research. In fact, when you see the various tests allegedly being used, I recommend you also do a little research to make sure that they're being applied correctly. We at Bradford and Barthel have this wonderful research tool that I strongly recommend you consider using too. I've used it prior to every single doctor deposition I take. It's very helpful. You may have heard of it. It's called Google. No kidding. Google is actually very wonderful for preparing for all of these things. So the statute actually says a mental disorder which causes disability or need for medical treatment has to be diagnosed within the specific criteria as outlined in the APA's manual. So does this utilization or this requirement that the injury be diagnosable via the DSM? Obviously, it definitely establishes a much higher hurdle for applicants, and that's exactly what the legislature in Sacramento wanted to do. There are 3 kinds of psychological injuries. There's your physical, mental. They broke a leg and now they're depressed about it. Yes, we still have those. Don't forget about 4660.1, but we'll talk about that later. But generally speaking, with regards to all issues other than PD, we still have legitimate, an applicant can make a successful physical mental claim. Second, mental. Perhaps, let's say, hey, they have PTSD as a result of seeing some robbery, and now they also have depression resulting from that, or mental physical. PTSD results in, for example, high blood pressure. All of these can be legitimate claims in California workers' compensation. Most psych problems result in physical symptoms, obviously. Headaches, stomach aches, crying, heart attacks. Does the labor code apply to these physical problems? Actually, the case law is confusing regarding whether physical problems resulting from psych problems apply, or rather the labor code and the labor code, section 3208.3 and its provisions apply to these physical problems. Some cases say that they don't apply to mental physical, that 3208.3 applies only to the psychiatric portion or the psychological portion of the injury. And there's a lot of case law in 2000, 2001, 2015, all writ denied, suggesting that's the case. However, we had a fairly recent case, the McCoy case, in which there was a disgruntled employee and there was a good faith personnel action defense, more of which we will talk about later. He claimed that the good faith personnel action, which is a legitimate defense, caused upset stomach, headaches, and other physical problems. He did not make the claim that it was an injury to the psyche. It was held as follows. The legislature made clear that it intended to limit, not expand, but limit claims for psychiatric benefits due to their proliferation and their potential for fraud and abuse. Therefore, any interpretation of the section that would lead to more or broader claims should be examined closely to avoid violating express legislative intent. So, good faith, the upside here, good faith personnel action defenses also preclude recovery from physical manifestations solely caused by a good faith personnel action. So we've got a good faith personnel action defense. It works with regards to the psychiatric claim. Well, it's also going to work with regards to the physical manifestation. Let's read it one more time because this is an important factor or fact. Good faith personnel action defenses precludes recovery of physical manifestations solely resulting from good faith personnel actions. So if you win on the good faith personnel action with regards to the psyche, you're also going to win with regards to the resulting physical problem if that manifestation is solely allegedly from the good faith personnel action itself. A few more in McCoy insights. What's the point here? McCoy is limited. Physical portions of a claim are not subject to the good faith personnel action defense, except to the extent that they were directly and solely caused by that defense. And we're going to talk much more about that later. Additional affirmative defenses. If the injury is diagnosed by the DS or diagnosable by the DSM, and it's predominantly caused by actual events of employment, more of which we'll talk about later, the defense can argue that they weren't employed for 6 months, that it wasn't the result of a sudden extraordinary event, that we have a post-termination defense, that there was a lawful, good, non-discriminatory, good faith personnel action. So lots of potential defenses. Let's talk about the higher threshold of proof. I said earlier that the old school used to be 10%. Now it's substantial or greater than 50%. But it must be actual. They must allege and demonstrate that their injury to their psyche is due to actual events of employment and that they are predominant as to all causes of the psychological problem. Actual events, let's underscore that word actual. Back in the old school days when I was first starting in workers' compensation, they didn't have to be actual events. It could be the applicant's imagination. They could believe, for example, that they were being undercut by co-employees, that they're being berated by their employer, and even if there was no objective evidence to support that, it could be found to be AOE COE. We no longer rely solely on the applicant's imagination. They must have a good faith subjective observed belief, and it must be objectively reasonable and verifiable. What about stress, for example, with dealing with angry customers? That would be an example of an actual event of employment. On the flip side, anxiety over the business's future, corporate downsizing, sizing the stock market, et cetera, those do not equate to actual events of employment, and that would not help with the defense. Actual events of employment, causation or correlation. This is an important factor, and let's just read this from the Hannah versus WCAB case, long ago. Work circumstances did not create or aggravate her psychiatric problems, but rather she brought her problems to the workplace and unconsciously projected them to the conditions and circumstances of her work. If you bring your problems to work, your psychiatric problems, and it's just sort of a stage for your for the showing up of your injury, of your psychological problem, that is not AOE COE. Heredis. Nature of the employee's duties was merely provided a stage for the injury. The duties did not cause the injury. Employment was a mere passive element that a non-industrial. So if you're born and raised obsessive compulsive, you go to work and suddenly you're OCD about your work, that is not AOE COE. That is a mere stage, a mere passive element for your non-industrial OCD condition. So what kind of events are not actual events of employment? We touched on this earlier. Generalized anxiety over one's future in a company struggling to survive. Fear of loss of a job due to management strategies. Interestingly, litigation is not an actual event of employment either. An employee's emotional reaction to an agreed medical examiner's opinion is not a compensable consequence of the industrial injury. Nor is the litigation process something we'll touch on later. If the applicant is stressed out by the litigation process, which can be stressful, if you consider the medical examinations, the personal inquiries, the cross-examiners at deposition, the stress of going to trial, all that can be stressful and quite understandable. They could quite understandably have a psychiatric or psychological response to that, but that is not AOE COE. They cannot make a successful claim based on that fact pattern. Substantial causation. It's an exception to the predominant cause requirement, which means they have to prove that their psychological injuries were predominantly caused or 50% plus caused by AOE COE factors. Substantial causation, however, decreases that requirement. If injuries resulted from being a victim of a violent act or from direct exposure to a significant violent act, actual events of employment must be a substantial cause of injury. What's a substantial cause of injury? It means at least 35 to 40% of causation from all sources combined. 35, 36, 37, 38, 39, 40. Which one is it? I don't know. The legislature just said 35 to 40. I don't know why they gave that range. It really has never made any sense to me. But let's say that there was a 35% psychiatric injury due to a robbery at work. This would be compensable under the substantial cause standard because of the violence involved. Predominant cause and actual events of employment. Here's the history. As I suggested earlier, back in 1993, the burden was the injury had to be demonstrably 10% AOE COE. Obviously, that was a 3-inch putt. Anybody could make that one. Post 7/15/93, it has to be greater than 50%. In order to establish that a psychiatric injury is compensable, the applicant must demonstrate by a preponderance of evidence, 50+%, that of evidence that actual events of employment were predominant, greater than 50%, as to all causes combined, unless, of course, as we suggested earlier, there's a violent act involved. Predominant cause is not actually defined, but it is predominant as to all causes. So it requires more than 50% of the causal factors. Only 50% won't do the trick. There was an applicant out there who had a doctor say it was 50%. They thought they'd made it, and nope, it has to be 50+% plus anything, just a smidge. What if you've got two or more separately diagnosable psychiatric components? How does that work, mathematically speaking? It's not sufficient if only one of the components is demonstrably predominantly caused by work. You got to prove that all the events of employment taken together are predominant. Let's take a look at this. Must prove, quote unquote, events of employment were predominant as to all causes of the psychiatric disability taken as a whole. So, and what can demonstrate this? Well, not lay testimony. Lay testimony can be used to demonstrate the injurious incident itself, but not the psychiatric injury. You need competent medical evidence to demonstrate that. What is psych? Speaking of psych reports and psychological reporting, what do they need? They need a history of the events, obviously, particularly those that contributed to the injury. An opinion as to causation. And in other words, was there predominant cause, 50+%, or substantial cause, where there's a violent act, 35, 36, 37, 38, 39, 40%. A discussion of all causes, AOE, COE, and non-AOE, COE that contributed to the psychiatric problem. A statement that the actual events of the employment were predominant as to all causes or substantial. An explanation as to why the AOE, COE factors of causation were predominant or substantial, and medical evidence consistent with the findings. It's not enough to discuss the AOE, COE or non-AOE, AOC. One more time, non-AOE, COE factors when addressing apportionment, because apportionment and causation of injury are two different factors, something we need to separate out. We will talk about that also with applicable case law. The predominant cause requirement. How about this case? We've got a psych injury because of, well, 40% of it was because of viewing a dead coworker, digging around in some of his or her blood, and driving home the person who killed the coworker. 40% was due to an industrial back injury. So we've got 40% due to the coworker death, 40% due to the industrial injury, and 20% non-AOE COE. When we look at the dead worker component, it's only 40%. It's not the predominant cause. When they look at the industrial back injury, the psychological injury was only for 40% caused by that in that physical injury. It's not predominant cause. So does the applicant in this situation win? Have they demonstrated predominant cause? As a matter of fact, they have. Why? Well, it's as to all, combining all separate AOE, COE causes. So it's not 40% and 40%, it's 80%. 80% of the AOE, COE factors contributed to the psychological problem. So it is, we do have predominant causation when you do the math that way. You might say, well, wait a minute, it's 40%, 40%, 20%. Wouldn't we apportion 40%, 40%, and 20% potentially? And that's true. We may apportion the permanent disability in that way, but 4663, the apportionment statute, nor 4664, the other apportionment statute, can be used to apportion causation of injuries. As I suggested earlier, it's limited to the causation of permanent disability, or they are limited to the causation of permanent disability. What about joining co-defendants? How does that work with substantial causation? Let's say we've got a construction foreman at employer 1. There are 4 injuries AOE, COE. No psychological problems claimed, no psychological treatment sought, no psychological treatment required. Later works for Elite or employer B, where there's a motor vehicle accident. As a result, there was an orthopedic AME. He said 35% of the orthopedic problems were from Browning and 65% due to Elite. The psychiatric AME said 65% of the psychological problems were due to the motor vehicle accident and 35% due to Browning. So how do we split up this? Liability? Well, it was held that you don't, because Browning's psychological claim, or the claim against Browning, is barred by 3208.3. Reason: the success of injuries with different employers may not be combined to meet the predominant cause requirement. So we can take a look at different causes with the same employer and combine them together to demonstrate predominant cause. But we can't do that with successive injuries with different employers. An important point. And here's the reason why, and it makes a whole lot of sense. A contrary ruling would allow the employee to, quote unquote, reach back to the dark recesses of his or her employment history and draw on ancient and minor injuries to combine them to demonstrate psychiatric injury, a substantial causation of the injury, AOE-COE. We've touched on this twice. Let's make one more point. Causation, make the point one more time. Causation versus disability, they are not the same thing. Causation or apportionment only applies after the applicant is MMI. Here's an example. The psych said that the depression pain disorder was predominantly caused by the ortho injury, predominantly meaning 50+%. PD was 20% from pre-existing anxiety, 30% non-industrial cancer, and 50% from ortho pain. None of these are predominant cause. None of these three are 50% plus. So the issue is the psychiatric claim compensable, even though the permanent disability is not predominantly caused by AOE-COE factors. We have a 30, we have a 20, we have a 50. None of these are predominant causes of the PD. And the answer is, of course, yes. Although the PD was not predominantly AOE-COE, causation of the injury was predominantly AOE-COE. Actual events of employment. Let's talk a little bit about that. As I suggested earlier, the applicant can't come up with some story in their mind and have a subjective belief that they've somehow been injured without objective findings and without it basically based on actual events of employment. They can't believe in their heart of hearts that their supervisor is actually a dinosaur attacking them, because that would not be an actual event of employment. This is up to the judge to decide, not a medical issue. What are actual events mean? It's a two-pronged test. First, there must be event. Something must happen in the employment relationship, and it must result from the employee's working relationship with the employer. Of employment means the injury may not result from a purely personal issue. If it occurs at work, it has something to do with work. The job must play an active or a positive role in causing the psych problem. It's not merely a stage for the applicant to suffer from the problem, something we discussed earlier. Of employment, what are some examples of, sometimes it's easier to define a term by explaining what it is not. And of employment is not gossip about a personal matter at workplace. It is not rejection of romantic overtures down at the workplace from one employee to another. It might be involving a supervisor and employee over whom they have supervisorial responsibilities, but not between co-defendants or co-employees rather. It is not a psychiatric injury stemming from a wife's rape by a co-worker and her long-term affair with another co-employee. Wow, that was quite a deposition. Actual events of employment. What are some specific findings? Actual events of employment can be cumulative effects of each day's stresses and strains. It can be a CT, in other words, involving work duties, rotating shift schedules, increased job duties, reprimands, being placed in the middle of an employer dispute. Precipitating physical injuries may also include psychiatric injuries from physical injuries, as we suggested earlier. Let's take a look at the Guthrie case. We had a physical injury. It resulted from financial difficulties, which is oftentimes the case, right? That resulted in a psychiatric injury. And the question was the psychiatric injury proximately caused by the physical injury? The holding was yes. And let's take a look what the logic was. Well, Labor Code Section 3208.3 mandates that the employee demonstrate by a preponderance of evidence that actual events of employment were predominant as to all causes. It does not follow that secondary or downstream effects of the injury, here unemployment due to the physical injuries, are to be treated as non-industrial, as a non-industrial cause. Don't be afraid to litigate, as I suggested earlier. That does not give rise to an AOE/COE claim, no matter how tough you are, no matter how many rough questions you ask at deposition or at cross-examination. What about actual events of employment versus a subjective misperception? Well, you already know from what I've suggested earlier, but let's look at the Berger decision. The applicant claimed that she was injured because of the harassment and persecution by her supervisor and coworkers. The WCAB found that didn't actually happen. She thought it was what was happening, but in fact, it was her own fault. She was a pain in the neck to get along with. She was impolite. She was unpleasant, and that was what was causing all the problem. The holding was her misperceptions, even though she honestly believed that she was being persecuted, her misperceptions were not actual events of employment. They did not actually occur. To allow an employee to harass a coworker, and when they respond unfavorably to a claim of stress-related injury to the employee's psyche, would increase, not reduce, the workers' compensation claim. You know, oftentimes when you're not quite certain which way the WCAB or the DCA is going to go on a psychological or psychiatric claim, oftentimes they will harken back to the legislature's desire to reduce the chances of, in particular, fraudulent claims, something that's been demonstrated by a number of legislative changes over the past 20 years. So what was the predominant cause in this particular case? It was the applicant's intentional abuse of co-employees. What would happen if that were allowed to be found to be AOE/COE? If you could go ahead and abuse your coworkers, have them respond in kind, and your emotional response to that would be the predominant cause of your AOE/COE psychological problem. That would make it very easy for any applicant who wanted to make a psych claim to do so. So the WCAB, or in this case, actually, I think it was the Court of Appeal, WCAB said we're not going to go down that path. How do we defend these things? You're going to need the testimony of co-employees or supervisors. I say it's essential. It may not always be true, but I would do my very best never to go into court without it. In fact, I would be considering settling outside of trial if I can't get the testimony from co-employees and supervisors. And that's probably going to be true for either side. Definitely more so for the defense. The employee's testimony can help him or her, but it's not absolutely positively essential. What is needed? Well, according to this case, the applicant did not, this case confirms that the applicant does not have to testify. In the Stayrick case, the defense argued that the judge couldn't rely solely on the medical reports, that the defense should have the right to cross-examine the applicant at trial time. And without that opportunity to cross-examine the applicant, there was no substantial evidence, and it also violated the defendant's due process rights. This is clearly a situation where the defense screwed up. The defense had every right to cross-examine the applicant at trial time, but they would have had to list the defendant, or rather, they would have had to list the applicant as a witness at the time of the MSC and subpoena the applicant to make sure that they showed up and testified. The defense clearly screwed up, did not do that, and now they're trying to say that, well, it doesn't matter because the applicant had to be there to be cross-examined, even though we didn't subpoena them. And the WCAB said that's, they weren't subtle here, they said that's utterly without merit. The applicant can win the case solely based on the medical reports. It does not require the applicant to testify. It can be sufficient for the medical evidence to support the conclusion that applicants' perceptions of the workplace stress were objectively reasonable. Speaking of not being, let's strike that. Always be nice to the person who's going to be judging your case on credibility. That's, of course, the judge. Credibility goes a long way in workers' compensation, psychiatric or psychological claims. And this is definitely a situation where you want to make sure you have the judge on your side. Let's take a look at this fact pattern. The applicant alleged he was harassed by the co-employee H. H, on the other hand, the applicant claimed that H micromanaged applicant. H testified otherwise. H testified, I'm not his manager. I couldn't have possibly micromanaged him. I never discussed his job performance with applicant. Nevertheless, applicant claimed that they were being singled out by a non-manager. The supervisor testified that she supervised applicant no differently than by other employees. What was decided? Well, the employer won, but was based solely on the credibility. What's the takeaway from here? If you didn't have the testimony, you didn't have your own witnesses in this case, we would have lost. So testimony is incredibly important. All right. Objective evidence of actual events is needed for the psyche. Objective evidence is not required for physical injuries caused by stress. The first time I read this, I thought, I don't think I understand. Yes, you need objective evidence of actual events of employment for the psyche, but we do not need evidence of actual events of employment for physical injuries caused by stress. What's the difference? Well, here's an example. Doctors thought that, or indicated that the stroke was due to AOE-COE stress. There was no finding that the stress was caused by objective factors, nothing to note. There was no harassment, no persecution. There was just this regular at work stress. It was held that the stroke was compensable. Here's the reasoning. The only requirement for physical injuries, unlike psych injuries, is that AOE-COE stress be a contributing cause of the injury. Less than 1%. The tiniest, most minute contributing factor for AOE-COE will do the job for a physical stress-related injury. Not true, of course, for the psychiatric injury, which must be predominant cause. Applicant was required to establish only that he genuinely perceived his work conditions to be stressful. Unlike a psych claim, where it has to be objectively verifiable, applicant was required to establish only that he genuinely perceived his work conditions to be stressful and did not need to show that the job duties were objectively or extraordinarily stressful. Actual events of employment, the takeaway, need not be attributed to the employer. Grand jury investigation regarding misappropriation of fundraising funds. There were no charges brought, but a co-employee sent, not a manager, a co-employee sent an email around to other co-employees accusing the applicant of misappropriating the funds. Question was, are these actual events of employment? Now, the employer had nothing to do with the grand jury investigation. The employer had nothing to do with whether the charges were brought or not brought. The employer was not the co-employee. The co-employee was, well, the co-employee. He or she was not a supervisor or in a management position. Nevertheless, the issue became, were these actual events of employment? And the answer was yes. The fundraising was an actual event of employment. The email was an actual event of employment. The grand jury investigation was an actual event of employment. Careful with those fraud referrals. The applicant was accused of workers' compensation fraud and arrested and acquitted. And the issue was, these events, which aren't attributable to the employer, can they be actual events of employment? And the answer is, you're darn right they are. All right, predominant versus substantial. We've talked about these a little bit already. General rule, the applicant must prove actual events of employment were predominant, the predominant cause of the psychiatric injury. The exception, of course, is the violent acts that we talked about earlier. If they show that they're a victim of violent act or direct exposure to a violent act, they only have to make a substantial causation demonstration, that 35% to 40% that we just talked about earlier. But how does the, we've already got that down, but how does the Labor Code define a violent act? How do they define a direct exposure to a significant violent act? Labor Code doesn't do so, nor does any regulation. Irritating, we do know that irritating behavior doesn't do the trick. We've actually got case law that says white correction fluid on the applicant's chair is not a violent act. White correction fluid on their family's photographs is a pain in the neck, but it is not a violent act. What is a violent act? Well, the Larson decision provided us some insight. There was an accepted ortho but a denied psychiatric claim. The applicant was hit in the parking lot, hit so hard that they fell down, hit their head, and actually lost consciousness. The defense said, this is not a violent act. We had nothing to do with criminal behavior. It was an accident. Well, let's look back at the statute, shall we? Let's see if I can find it real quick. In the case of employees whose injuries resulted from being a victim of a violent act or from a direct exposure to a significant violent act. All right, so the question became, in this particular case, does a violent act have to be a criminal act or a semi-criminal or quasi-criminal act? And the WCAB said, nope, it does not. For purposes of 3208.3, a violent act can include anything involving a strong physical force or extreme or intense force. Now, this is interesting. I think the only takeaway from this is that it doesn't have to be, the violent act does not have to be criminal or quasi-criminal. The further definition or refinement in this case, the strong physical force or extreme or intense force, I think provides us no additional insight. What is your definition of strong? What is your definition of extreme? What is your definition of intense? We have about 600 plus people involved in this presentation today, and I'll bet we could come up with 600 different opinions and definitions of what strong, extreme, or intense is. So probably going to be the same of all of our judges and our WCAB commissioners. That remains to be seen. Some more violent acts. The Clatcher decision, we had a violent act of being forcefully punched in the back and knocked on the floor by a coworker. That seems to qualify as a violent act. How about being assaulted by a coworker? Boy, that picture is, that's exactly what I sometimes feel like. Let's go to the 6-month rule. I love the 6-month rule. I'm sure everybody is at least vaguely aware of the 6-month rule. Let's read it, shall we? No compensation shall be paid for a psychiatric injury related to a claim against an employer unless the employee has been employed by that employer for at least 6 months. Wow, that seems so simple, so clear. They work for 6 months, or they don't get the workers' compensation claim, or don't find a AOEC a week. That seems simple. Pretty far from it. First off, the 6 months need not be continuous, and even if you don't have 6 months under your belt, applicant, you can still overcome that 6-month rule by demonstrating a sudden and extraordinary event. We'll talk about that now. What is sudden and extraordinary? According to the Garcia case, which came around about 15 years ago, quote, in our view, the sudden and extraordinary language is limited to occurrences such as a gas main explosion or workplace violence, the type of events which would naturally be expected to cause psychic disturbances even in a diligent and honest employee. Note that verbiage, diligent and honest employee. What's the message there? And the message is there that we find that, or have found historically, that a lot of psychiatric or psychological claims were brought by folks who are not terribly diligent and honest. And these legislative changes were aimed at limiting those suspect claims. What are some more violent acts? Well, the Garcia case. Applicant this was, I believe, the first case that discussed overcoming the 6-month rule via a violent act. The applicant suffered an orthopedic injury to her back. It was held, she claimed that, well, that qualifies as sudden and extraordinary. I it happened suddenly, and it was extraordinary because I'd never had a back injury before. It was held, no, that's not enough to do the job. The District Court of Appeals said, in our view, sudden and extraordinary language is limited to occurrences, as I said earlier, of gas main explosions or workplace violence, not just an industrial physical injury. If any and all industrial physical injuries qualified as sudden and extraordinary language, the sudden and extraordinary events, the entire rule, the 6-month rule, would be swallowed up by the sudden and extraordinary exception. So just because they've got a physical injury doesn't necessarily do the trick. All right, what about this situation, the Dreher situation? The applicant slipped on a wet sidewalk and suffered some very serious and remarkably serious orthopedic injuries, far more significant than one would expect given the relative minor quality of the event itself. The question was, given the extraordinary severity of the injuries, does this qualify as sudden and extraordinary? And the answer was absolutely not. Well, yes and no. It was sudden. When you slip and fall, gravity works very suddenly, very quickly, and it gets your behind to the ground in a fast manner. But is it extraordinary? Absolutely not. Lots of people slip and fall lots of times on wet sidewalks. Quote, if the argument were made that an accidental injury constitutes a sudden and extraordinary employment condition, we would reject it. For one thing, such an interpretation would mean that psychological injuries resulting from accidents would not be subject to the 6-month rule, but such injuries arising from a CT would be governed by that limitation. Accordingly, although the applicant's injury was more serious than might have been expected, it did not constitute, nor was it caused by, a sudden and extraordinary employment event. The evidence shows that he routinely walked between buildings on concrete walkways at the work site, and that he slipped and fell while walking on rain-slick pavement. Why do we have this 6-month rule in the first place? Well, the Hansen decision told us that. In many employer-employee contracts, the new employee is customarily on probation during the first 6 months of employment. It is during that period when problems between the employee and the employer or supervisor often occur. Those problems often result in disciplinary action, resignation, or termination, and lead to claims for psychiatric injury due to stress. And that was the claim, or that was the situation we had. There was a lot of unemployment, and the employment market was pretty bad when this legislation came about in the early 90s. And applicants employees were kept a job for a month or two, and then were laid off, and we'd go to the next job, and we'd quit and go to the next job. And they were collecting psychological or psychiatric claims for each and every employer as they moved along. It was decided we can't do that. They've got to at least work with the employer for 6 months before they could have a legitimate claim. The rule applies to all psychological claims, but what about those arising from the AOEC or physical injury? Yeah. Although a claim for psychiatric injury which rests on an objective physical injury may be somewhat less likely to be fraudulent than one based on stress, there remains a substantial potential for the fraudulent inflation of a claim by adding the alleged psychiatric injuries. The WCAB, well, in more particular, the legislature was just sick and tired of a psychiatric or psychological add-on for every single orthopedic and other physical claim, which was really what we were seeing in the late 80s and early 90s. They said, we've had it. We're going to have rules that fight against that. What are some surprises? Even if the 6-month rule applies, you can get psychological treatment as a compensable consequence if it's necessary to cure and relieve the effects of the physical injury, not the psychological injury. So let's take a look at this fact pattern. The 6-month rule applied. The psychological claim was barred by 3208.3. Applicant nevertheless obtained a medical legal. You object. What are the results? Just one more time. You've got the 6-month rule applies, which means it's barred by the 3208.3D rule. There is going to be no successful workers' compensation claim on a psychiatric basis. You object to the medical legal saying There's no good reason to get it. I should not have to pay for it. What's the result? Duh. We always pay for everything, right? And that's exactly what was held in the Lal case. How do we count the 6 months of employment? It must be 6 months of actual service, which is helpful to the defense. The time accrued while TD doesn't necessarily apply, even if they are, quote unquote, on the books. Let me show me the math. There is a math here. But do we calculate calendar months? Do we calendar actual days worked? Do we calendar, or do we rely on weeks worked? It's kind of confusing. Let's take a look at the case law. Hamilton, writ denied. Got a CT claim. Day of hire 9/14. First day work 9/15. Working period 5 months 26 days. Oh, so very close. But he filled out the new hire form. He applied for the job on 8/20, which would give him over 6 months. He also picked the computer up from the office for training on 9/12. So the question is, and then remained on the books until 1/25, which would make it even far greater than 6 months. So did the six month bar apply? Absolutely. Why? Well, first off, he wasn't paid for picking up the laptop. Second, the lack of formal termination and keeping the applicant on the health plan does not constitute a, quote, actual days of service. Does not constitute, quote, unquote, actual days of service. Think about this. There's a good public policy consideration for this. In other words, this case encourages employers to do the right thing. In what way is that true? Well, it doesn't punish employers for keeping the applicant or keeping the injured worker on the health plan for an extended period of time. Had this decision gone otherwise, employers would be inspired to take them off the group health immediately upon an industrial injury so as not to extend the 6 months. How about the Oakland Raider case? Got an NFL player, not surprisingly. He entered into an oral agreement or an oral contract in March 2 to play for the Raiders. They even shook hands on the thing. Contract was signed 2 weeks later, and then he trained during the off season. Received termination notice on 9/9. So if you look between the date of the contract being signed and the termination date, we have just under 6 months. But if we take a look at the oral contract date through to the termination date, we've got our 6 months. And the question was, does shaking hands or signing a contract equal actual performance of the job duty? And the answer was no. The claim was barred by the 6-month rule. And the reason was actual services didn't begin until working in the off-season program. I was sick. I couldn't come to work. The dog ate my homework. Do days off of work for non-industrial illnesses count as part of the 6 months? Well, let's take a look at the Mills case. The applicant worked exactly 6 months. So obviously the defendant was very inspired to prove that some of these days did not count. In fact, the applicant was off of work for 2 weeks for a non-AOE COE surgery. So the employer said, well, it was 5 months and they only worked for us for 5 months and 2 weeks. The 6-month defense should apply. The holding was, nope, absolutely not. Quote, the applicant was off every weekend, and it would be unreasonable to interpret the statute as counting weekends against her in determining whether she completed the 6 months of performance of actual service under the Garcia decision. So if the weekend days off aren't going to count, being off of work for a non-industrial surgery is not going to count either. What about TD? How does that count? Get this. This is really interesting. You don't need all of the 6 months to qualify for passing the 6-month test. You don't need all of the 6 months to occur before the date of injury. In this case, the applicant worked for 2 months. thereafter was on TD for 3 months, then returned to work for 2 months and was laid off 2 months later. So the question is, were they performing the benefits to the employer? Were they working for 4 months or 7 months? Were the actual service for 4 months or 7 months? And the answer was 7. It was no successful 6-month defense. The reasoning was the post-injury employment can count towards the 6 months if they return to work after the injury. I was shocked by this decision, perplexed by this decision, and I remain shocked and perplexed by this decision. I hope you are too. All right, we have more to cover in terms of the 6-month rule and a whole lot of other factors to consider. But at this point, we're just about to go over. So I'm going to give you over to Tammy, and I look forward to completing this presentation with you next month. Have a great afternoon.